I'm Nate Eaton, and this morning I'm talking with Bonneville County prosecuting attorney Danny Clark. He has been a prosecutor for about 20 years and works with the Idaho Prosecutors Association. And Danny, I know you can't speak specifically to the Daybell case. You're not involved in that. But I will tell you that over the past week, the number one question I've been asked is, so now Lori Daybell's not competent. She's never going to face a judge, and she's I guess, free in a way for the alleged crimes. So I wanted to ask you for some clarity. The psychiatrist has deemed Lori Vallow Daybell incompetent for trial, but what does that mean?
Well, in effect, it's a very well-educated opinion on her competency, but that's all. In Idaho, under Idaho Code 18-212, competency must be determined by a judge. And so we seek, or parties will seek, opinions of various experts on different things, in this case, mental health, to give an opinion to the court. But ultimately, the determination of competency is a judicial ruling made by a judge. That has not occurred as of yet. And so I've seen some of those same reports. They're a little bit of a misnomer because that determination has not been made, as I believe the prosecutor in Madison or Fremont is contesting those findings, at least as of now.
So the mental health professional says Lori Vallow Daybell is not competent for trial, but the judge still has to say yes or no, and the prosecutor can contest it. And what does that mean? Bring in their own expert or question some of the findings? What exactly does that mean?
Probably either or both. Competency is a very specific thing. Competency does not mean there isn't a mental illness. It doesn't mean they don't suffer from certain things. It means simply comprehending or understanding the proceedings against them, that they've been charged with a crime and what it is, and able to assist their defense, assist their attorney in their defense. Very, very basic, rudimentary understanding of the system in order to be competent. And so it's possible this report may go into all sorts of different things. I don't know if this one does, but I've seen reports that go into different things regarding a mental illness, but don't really speak to fitness to proceed. And so those are questions that the judge will be specifically asking or wanting answers to, or getting some clarity on before making a determination.
So let's say the judge does agree with the professional's opinion. What happens from there?
Basically, what happens anytime someone is deemed incompetent, there is a pause in the proceedings. That's the best way to describe it. The proceedings are simply paused. Initially, it's for up to 90 days. During those initial 90 days, the defendant is placed in a facility to receive treatment for that mental illness in order to make an effort to restore them to competency. That's what happens in the vast majority of cases. And a report is provided to the court whether they've been restored to competency or not. If they have, the proceedings continue. The pause is taken off, and the case just simply starts where it was.
And restored to competency could be medication, counseling, variety of options there in the jail or at the state hospital?
All of the above. It would not be, generally is not at the jail. Placement's usually at a state hospital or something like that, unless there's a finding that the person is dangerously mentally ill. And in that situation, the defendant is placed in the Idaho Department of Corrections custody during that time.
Okay. So 90 days, they're doing evaluations, basically trying to get the person competent to go before the judge. What happens after 90 days?
Well, if at some point during that 90 days, the defendant is determined by the Department of Health and Welfare to be competent, those findings are provided to the judge to then make a judicial determination whether they're competent or not. If during those 90 days, the defendant is still not deemed to be competent, the court's notified of that. The statute then gives a provision for those proceedings to be extended for 180 days. So now we're 6 months after those 90 days for the same treatment, same effort to restore that competency. If at some point the defendant is deemed to be not competent and not likely to become competent, then they're simply ordered committed to the Department of Health and Welfare until such time as they become competent.
Now, one other question people are asking, Danny, is could she plead insane? That's not an option here.
Not in Idaho. Idaho is one of a handful of states where there is no such thing as an insanity defense. Now, a defendant here, just like elsewhere, can say, I was not able to form the specific intent for that crime because of some mental illness. And so so in effect, the defense is still allowed as they're allowed to attack whether they had the specific guilty mind that's required by law. But to simply say I'm insane, therefore not culpable, is not something that's allowed in Idaho.
Any idea, Danny, how many actually are, or the percentage of how many cases actually never proceed because of competency issues?
Well, this is going to be anecdotally, but I've been doing this a while. I only know of one case in Bonneville County in its history where the case was paused because of a mental illness and did not resume. What that means, that's a lot of cases, that's a lot of evaluations, that's a lot of findings of incompetency to later be determined competent. So I would imagine this would be similar to those cases, but I just don't know at this point. Very, very rare for a case to be paused and not resumed.
And if someone can never be declared competent, it's not like the charges are dropped, right? I mean, the charges are with them for life. So in 50 or 60 years, they could still be waiting for their trial.
That is correct. I haven't experienced that.
Yeah.
but yes, in theory, the case is paused until it can be resumed. The defendant is placed in a treatment facility or in IDAHO custody to restore them to competency. The entire statute, we're talking about 18, 210, 211, and 212. All of those statutes contemplate this being a temporary issue.
So then, Danny, once someone is declared competent, it continues as normal, just like it picks right back up with, if they haven't been arraigned, with an arraignment or a preliminary hearing or whatever the case may be.
Sure. I've had a case just recently where the case was set at the preliminary hearing stage. The proceedings were paused. The defendant was deemed incompetent. It was later restored. The court set a status conference, scheduled the next proceeding. We had a preliminary hearing a couple of weeks later. I've had a different case where a defendant was I believe was after his arraignment, close to his pretrial, so probably a month or so away from trial, was deemed incompetent. The case paused at that point. When it was started again, it started again right there with a pretrial and a trial date.
Is there a time frame when a defense attorney or a prosecutor might ask for a psychological evaluation? I mean, could you, in 6 months after someone's been charged, think, I don't think something's quite right here. I don't think they understand. Or is that normally done at the beginning, or does it vary?
It'll vary. Let me answer that a couple different ways. Most of the time, the request is made by the defense attorney, and that's for obvious reasons. They're the ones that are having personal interaction with that defendant. Very rare. I believe I've asked for an eval just a handful of times in 20 years. And that's just because of my interaction with them, for whatever reason. But most of the time it's the defense attorney. That's the person that's spending time with them. Most of the time that happens on the outset. Generally, when someone is placed into custody, possibility that there's some mental illnesses that are not being effectively treated out in the public at large. So most of the time it happens at the beginning, but I've had cases where someone was determined to be incompetent 3 times on the case before it got to a conclusion. I've had cases where the defense attorney brought the issue up 6 months into the case, and we all respected his or her decision to bring that issue up at that stage based upon what they were seeing. So it certainly varies. More common at the beginning. but it certainly can occur at any point.
And the standard is you have to be able to understand the crimes you're accused of and be able to assist in your defense. It's really
correct. And the statute, I believe, specifically says a rudimentary understanding, very basic understanding of the system and assist in your defense.
Danny Clark, thank you so much for your knowledge and assistance in helping us understand this.
Thank you, Nate.